Yeah, I'm probably in a rare minority in being very fired up about this issue, but it strikes me as fundamentally unfair, and it's what's at the heart of the Trump case here as well. Is
Hmm.
would Donald Trump or his attorneys or his general counsel at his firm been left to wonder whether they were doing what they were doing was a crime or not? I think the answer to that question is yes, just as
Mm.
we're left to wonder today. And I'm glad this case, for what it's worth, for the American people is getting the level of attention that it is. But if Donald Trump had to wonder whether or not you were going to charge this as a campaign expense or you're going to charge this as a personal expense to know which one was the crime versus not, and the irony is, had he gone the other way, there'd be an entire separate legal charge of misuse of campaign funds to make a personal hush money payment. But if he's in that situation, it seems like, yes, it's especially bad for the future of our country for him as a presidential candidate to be able to deal with prosecution on that basis.
Hmm.
But it is also, at least in part, a diagnostic of a deeper problem in the criminal law that an ordinary citizen could find himself in that same position too. And I just have very different attitudes of whether the scope of such punishment is civil, right? If it's just talking about a financial or monetary penalty, and the level of certainty that we require you to have on the facts is a 50.1% preponderance of evidence standard for the same reason we can apply some level of tolerance for vagueness in the law of whether or
Hmm.
not you're left holding the bag, versus to say that you're going to have the ultimate restraint on your liberty, which is to be locked up at behest of police force to backstop it. And in that instance, it feels to me that we should not. And maybe you said it was used to be Supreme Court doctrine. Maybe I believe it should be too, that if reasonable men have to speculate on what a law means, they shouldn't be going to jail.
Hmm.
Is that something that Congress, I doubt it would ever be a popular enough cause to take up, but in theory, is that something, a blanket sort of provision in the criminal code that Congress could adopt, is to codify that, to say that from this date certain forward, criminal laws are going to be interpreted in conjunction with the rule of lenity, basically statutorily codify either the rule of lenity or the reasonable man speculation standard, or even using a litmus test of a judicial dissent as a basis to do it. This seems like the kind of thing Congress could do retroactively to the criminal code in whole.
Yes, it could, but of course only for federal crimes.
Yes.
It would not have the authority to do that for state crimes. But just so your viewers and listeners are clear, in the Trump hush money prosecution, let's not forget, it wasn't just interpreting a statute, it was what statute is he being charged under?
Yeah.
What offense, what crime is he being charged with? The Supreme Court has said for over 150 years a defendant has a right to know the specific offense with which he's charged. That's fundamental to our criminal justice system. We don't want to, be living in the world of Kafka's The Trial, where folks are prosecuted, convicted without ever being told what the specific crime that they're being found guilty of was. So that's different from this very interesting question of interpretation that you're raising.
Yeah. And how do we deal with that problem? Because there's the rabbit hole we went down on dealing with the question of interpretation, but the broader question: how do we stop this from becoming the ordinary precedent in American politics? To take this back to the political context where this becomes the new means by which we adjudicate who leads our country. I'm
Well,
worried about that, and I know you
there's
are too.
very worried, very worried. There's another doctrine that comes into play here that folks might be interested in hearing about. Very difficult to prove. It hasn't played a huge role. Maybe it should play a bigger role, and that, of course, is the doctrine of selective prosecution.
Yeah.
What's that? You're not constitutionally allowed to go after somebody. The state district attorney cannot prosecute somebody where the motivation for the prosecution is to go after them because they're a political opponent, because you don't like their political views, retaliation for their political policies, try to undermine their candidacy. If that's the motivation for the prosecution, that's just straight up unconstitutional from the get-go. Forget all this stuff we've been talking about: Sixth Amendment, interpretation, rule of lenity, unconstitutional from the get-go. And of course, many people feel that's just what Bragg was doing. Many people feel, and I'm talking about people on both the left and the right, they sense that this prosecution would have never been brought if it hadn't been Donald Trump as a defendant, and would never have been brought if Donald Trump hadn't been running for president again. And a lot of people say it's completely clear that this is a politically motivated prosecution. It should be unconstitutional from the get-go.